Please, Your Lordship. We have filed a writ appeal against order of the Honorable Single Judge, Your Lordship. It was filed yesterday, Your Lordship. We have some urgency, Your Lordship. The petitioner service
What is the subject matter of the writ?
on 29th, Your Lordship.
What is the subject matter?
Subject matter, Your Lordship, the petitioners, Your Lordship, their appointment has been challenged, Your Lordship. There are 3 rounds of litigation, Your Lordship. In 2008, they were appointed. They were continued till this judgment has been.
Appointment can wait till 19th. Next.
May I please, Your Lordship, my lord, there is some urgency in this writ appeal which we have filed on 26th. My lord, matter relates to no confidence motion against the president. Learned single judge correctly held that the procedure adopted by the authority that is wrong, so it is quashed. But surprisingly, the learned single judge again asked for a holding of the meeting on 9th when there is nothing in the table, because the mandatory provision is there has to be requisition to the president. That requisition is not there. Because of that, the learned single judge set aside the entire process. Now, learned single judge is asking for the meeting when there is no requisition at all.
What is your request?
My lord,
What is your request?
my lord, for listing the matter tomorrow or day after tomorrow, because on 9th the election is held.
Day
Supposed
after day after tomorrow.
deeply obliged.
May it please, my lord. With the consent of the other side, I beg to mention item number 35 and 36, my lord. These measures may be come up after vacation, my lord, any date subject to your lordship's convenience.
On 3rd of November, Your Lordship. I am for the response.
I'm deeply obliged, my lord.
I also beg to mention, Your Lordship, item number 27 of today's list, Your Lordship. In this case, I am filing a affidavit in reply to the affidavit in opposition filed by the PTC, Your Lordship. Let this matter come up after vacation along with our affidavit.
Next.
Please, Your Lordship. Lordship, I'm praying for listing of this writ appeal, Lordship, that was filed on 36/2022. The matter pertains to the promotion of the petitioner from the post of senior assistant to the superintendent. So in that view of the matter, Lordship, can it be taken up there tomorrow or day after tomorrow or on Friday, Lord?
On 20th of October. Next.
May it please, Your Lordship. With the consent of the other side, my lord, I'm mentioning item number 31, my lord. This matter will be taken up after the vacation, my lord, and I'll file an affidavit in the meantime, my lord.
31.
31, my lord.
Matter.
Matter.
Next.
Highly object.
May it please, Your Lordship. My lord, I beg to mention item number 26, my lord, with the consent of the other side, my lord. My lord, matter may be taken up after vacation, my lord. Contempt case, my lord.
Every I think majority of you want after vacation anyway. Next.
My lord, obliged.
May I please, Lordship? Lordship, I beg to mention item number 3, my lord. In this case, we have been newly included, my lord. Lordship, we need some time, my lord. Harassment. Lordship, I am applying for harassment of 5, my lord.
Serial number 5,
3, my lord.
not 3. Okay.
May I please, Your Lord. Lordship, with the concern of other side, I beg to mention item number 22 and 23. My lord, matter may be come on after vacation. My lord, learned senior counsel Mr. R.P. Kagoti is unable to come due to his accident, my lord. So, matter may be taken up.
Wait, please, my lord. My lord, with your lordship's kind approval, may I pray for listing of a writ appeal on Friday, my lord? Matter is of some urgent in nature, my lord.
What is it about?
My lord, the appellant before your lordship has been relieved from his duties but is yet to be released. We have challenged this order before the Honorable Itanagar bench, my lord, and the Honorable Court rejected our interim prayer. So we are before your lordship against the interim.
Another appeal may not come here.
No, my lord, we have applied for permission, your lordship, and your lordship has pleased to grant the permission, my lord. We have filed the appeal.
How did you know that I have granted permission?
My lord, we have submitted an application to the registry, my lord.
No, how did you know that I have granted permission?
I'm sorry, my lord, it was addressed to your lordship, the application.
How did you know that I have granted that permission?
I received a phone call from the registry, my lord.
When?
Yesterday, my lord.
At what time?
Around 4, my lord.
They are very quick. Who called you up from the registry?
Perhaps it will be the assistant, my lord.
Who?
I do not I'm not aware of his name, my lord.
No urgent. Next.
Yes, may I please your lordship? That's why I beg to mention item number 15, lordship. I would like to withdraw this item. It's become inflexible.
The main matter has been heard.
No, lord. It's become inflexible. 15.
Dismiss as withdrawn. Next.
Lordship, with the consent of the other side, Lordship, I beg to mention item 30, Lordship. We'll file an affidavit in opposition, Lordship. We need some time, Lordship.
Item number 30.
30, yes,
It's
Lordship.
the matter topic
Lordship.
to be listed for hearing. Next.
May I please the Lord?
Oblige,
It
Lordship.
is already
consent of-
it is for final year.
May I please the Lordship? With the consent of the other side, I beg to mention item number 37, Lordship. It may come out after vacation, Lordship.
Will like.
Hmm?
Yeah, that's right.
Next.
Yes, your lordship. My lordship, it's about listing of matter. Can it be listed on 29?
What is the
It's
matter? about?
regarding med appeal.
Made appeal, there is no urgent. Next.
Please, your lordship, I beg to mention item number 44 of supplementary list. Lordship, earlier advocate would have withdrawn this Wakalatnama and we are going to file our Wakalatnama today. So matter may be taken after vacation, lordship.
For you, we got the matter listed in a separate court and now you are asking for time. Your choice. Grant him that. Next.
May I please, your lordship?
Who appears for the railways? Anybody for railways?
Lordship, I'm appearing on behalf of Mr. R.K.D. Chaudhary, lordship.
No. For railways?
For railway also, lordship.
Railways also.
Railway also.
Are you going to do anything with this land?
Lordship, I have to take instructions regarding that. lordship.
You be little loud.
I have to take instructions regarding that.
Tomorrow.
lordship. Yes.
Mr. Chaudhary,
My-
we would like to have an amended petition because there is no affidavit also of the petition.
Yes, my lord.
Record.
In fact, ideally, the Honorable Supreme Court ought to have asked to file a fresh petition, but it has been transferred, so we have to make amendments. My lord.
Not only amendment, you will have to file a because as you are aware, the affidavit must only one copy generally is being sent.
My lord,
So on oath, something should be there on our record.
my lord.
You file it in a proper manner, even grounds in 32 and 26 may differ.
Fine.
At the request of Mr. M.K. Chaudhary, learned senior advocate, assisted by sir. Should I keep it on 19, 20th? When do you want?
As your lord, please.
Now, after reopening, which date?
My lord, let it be on 7th.
7th November.
My lord.
Oh.
All right.
At the request of Mr. M.K. Chaudhary, yes, sir, to 7th November. Next.
Item 4.
I'm not providing anything in the order that you may do it, but you please do it. You write, meanwhile, the amended copy of the petition be
My lord, it has to be in our format, my lord, in High Court format.
submitted by the petitioner in proper format and by hand on an affidavit.
Right.
Next.
May I please, my lord, this is a matter which came to this honorable court, to Supreme Court of Sikkim High Court.
Somebody has got video conference.
Matter has to be heard finally, my lord. The pleadings and other things are complete, and we have given a written argument. A written argument is also on
Both the
record,
sides have given written argument.
lordship.
Yes.
So, your lordship,
So who appears for Sikkim government
I'm for Sikkim, my lord. The government
for
of
Sikkim
Sikkim
government.
government, my lord.
and who is for the respondent?
And
My
then
friend will apply.
Mr. K.N. Chaudhary, sir, is
K.N. Chaudhary.
leading me in the case.
Because we have seen the written arguments are also there.
Lordship,
Yes, it's
because
there.
last time, my lord, the matter was heard at length extensively, and thereafter, my lord, but now it has to be heard afresh.
Heard Mr. UK Nair for the senior advocate assisted by so for the appellant, and Ms. So for Ken Chaudhary, senior advocate for the private respondent.
Lordship,
As can be seen from the record and also as pointed out by learned counsel appearing for the party. The pleadings are complete
Lordship,
and even the written submissions have been submitted by the
both
learned advocate. The learned advocate for the appellant has also submitted the list of the judgments on which reliance is placed. Such an event, the matter be fixed for hearing in the week beginning from 21st of November.
Lordship, Lordship, Lordship.
Next.
Much obliged. No difference. We'll take a take.
My lord, I'm sorry, my lord, may I make a prayer? Let it be 9th instead of 7th, my lord. 7th, I was 9th.
9, no problem.
Obliged.
My lord, may I pay this item may be taken after vacation, not because, my lord, new standing counsel of income tax has been appointed. My lord, temporarily CGCs were, my lord, as a CGC, we were handling the income tax matter. Now we are in the process of handing over and taking over the files, my lord.
Next.
My lord.
At the request of Mr. Kyle appeared
My
in
lord.
the other matters, then somebody was here from his office. The registry is directed to show name of Mr. S.C. Kyle for the appellant.
My lord.
Which item? Item?
Item 5, my lord.
5.
5.
5.
That's not an income tax matter.
It is income, my lord. The challenge is made by the income tax department.
Next.
Not after vacation.
At the request of Mr. Gupta, extend to 20th of October. Next.
My lord, I'm sorry, my lord. I have mistaken. There was a confusion, my lord. It's not an income tax matter, my lord. There is a. I have done.
Gupta, what are you?
My lord.
You're making a mention without even going to
My lord, no, my mistake. Can it be taken at after vacation, my lord? I completely skipped, my lord. I'm extremely sorry.
But you are appearing for the petitioner.
Yes, in this matter, my lord, I'm appearing.
So are you going to continue or you are?
My lord, after vacation will be taken because on the last date, my lord, the registry was directed to.
It is against the CAT order. That must be.
Yes, yes, my lord.
Simply write at the
After.
next.
Obligation.
Mr. Salio is there. Mr. Salio is there.
Sixth, my lord, Mr. Silo used to have, this is on online, my lord.
Permit him.
He have to, he'll address the court, my lord, by, my lord, this online, my lord.
But he has not got any permission. He was to submit that certificate.
My lord, through me, my lord, he has provided a copy of the passport, my lord.
Whatever it may.
My lord, I provide, my lord, on his behalf, my lord.
But then you file it in a proper manner. This is not.
If my lord, we'll file it, my lord. If my lord directs, my lord.
File it properly.
My lord.
What is your name?
D. Gogoi, my lord.
T. Gokoi.
Gogoi, my lord.
Mr. T. Gokoi for Mr. L. Salio. Says that it is of your brother.
My lord, yes, my lord. That Mr. Yes, ma'am.
For the state, my lord.
You can part with the copy to your learned friend. He can take it over, but we would not have, because let it come on oath.
My lord.
It is always better. Otherwise, they will say that it is correct, not correct.
I understand, well, this will be provided, my lord, by affidavit, my lord. Acknowledgement.
When do we keep it?
After vacation, my lord, I have a fixed date, my lord. Can I?
After
20th, my
Is he
lord.
coming for any matter?
If, my lord, if this matter is fixed, he will come, my lord.
After 20th, I pray, my lord. After 20th October.
9th of November?
Very well, my lord. Meantime. Acknowledgement.
Yes, counsel, you will take instructions on that statement of Mr. Das Gupta.
I have not received the instruction because
We will not entertain the appeal. Before single judge, if your counsel concedes, there is nothing on record to show that he was not authorized.
actually
He is a senior advocate.
I have asked for instruction, Lordship, that till today they have not furnished me the instruction. So let it come after vacation, Lordship.
Next.
Of like.
May I please your lordship? Mr. A.R. Guya is on leg, so kindly pass over the matter for typing. Like.
9 to 13 virtually are same.
In these matters, the issue is regarding the invocation of a bank guarantee. While going through the matter, Your Lordship, one thing struck me, that if the bank guarantees themselves are unconditional, Your Lordship, then the scope of interference in the invocation of such a bank guarantee would be very limited. But in the writ proceedings, Your Lordship, those bank guarantees were not brought on record. So I'm praying for leave to bring those bank guarantees on record, Your Lordship. In this.
File proper application.
Yes, Your Lord. We'll bring the bank guarantees on record.
The bank guarantee were already encashed. There is no question of now bank guarantee. Any single judge has not interfered with the invocation of bank guarantee. Bank guarantee has already been invoked.
Let them file affidavit, then you can tell us. Even otherwise, according to me, the cause does not survive. According to my opinion, now the cause would not survive. If the bank guarantees are already in.
No, the issue is not that. Issue is only whether they can forfeit the security or not. Because the terms and conditions of the NIT were changed after the allotment of the work.
Mr. Saraf,
My lord.
Their accusation is that instead of filing a suit, you have filed a writ and got it the prayer. Otherwise, they would agree. Now, if the bank guarantee has been encased, what we have to do? Tell me.
The learned single judge has directed the refund of the forfeited amount, and that is the suit or not. When the action is contrary to the arbitrary and absolutely.
Therefore, it can be looked into it.
No, certainly, when you lost, you lost in the past interim order. So,
therefore, anything survives virtually in this appeal.
According to me, the appeal, nothing is there because the learned single judge, whatever decided, that is on the basis of the Supreme Court decision. Unnecessary, I don't know.
Mr. Pathak, take instructions unnecessarily. Anything survives now.
Your Lordship, the issue is that finding was recorded that a decision which was taken on completely commercial and contractual consideration, Your Lordship. That
but there is a particular stage in every matter, Mr. You have missed that part.
Yes, Your Lord. So just because
that way, if the learned single judge would have decided in 22, you would have relied upon the later judgment of the Supreme Court, but we can't redo everything.
Lord.
If that is in your mind, now it can be looked into 2022 1 SCC.
Because such a finding may, Your Lordship, open us up to further action, Your Lordship. That is our apprehension.
If this is allowed,
Mr. Saraf, let him argue.
No, I am saying if this is allowed, then at the condition they will change the conditions and they will say that you go to suit, you will take the money. That will be too unfair.
If that would have been absent, you would have been relegated to that remedy.
Remedy of suit?
No. If that situation would not have been there, then the learned single judge may not have entertained the petition.
Certainly, I fully agree.
Because then it is a commercial dispute.
Actually, I would not have said it. After vacation,
you take instructions. Why do you want to prolong? Your officers also should take a practical view in the matter.
Yeah,
If the bank guarantees are encashed down, it is an academic.
Your Lordship.
Anyway, which date do you want?
Lordship, immediately on reopening, Your Lordship, whenever it is convenient for a
No,
Lordship.
it is convenient to accept 26 and 27.
Let it
27
be
and
on
28.
the 3rd of November, Your Lordship, on a Thursday.
Huh?
3rd of November.
3rd of November. At the request of Mr. KP Patel. आपका appearance was next. All are similar up to 13. Mr. Saraf, you appear in every matter.
Five matters.
Next. R. Dubey is common. Next.
May I please, my lord? My lord, my technical bid was rejected on the ground of non-submission of hard copy of signed bid document. Lordship, may come to page 116.
Yes.
So there are 3 columns. The last one, SD Enterprise and Asut Kalita. We were joint venture. So whether qualified in technical bid, no. If no, reason for rejection, hard copy of signed bid document not submitted. This is the reason given, my lord. And my lord, the reason for not submitting the hard copy of the signed bid document, it was an online bid, and I had uploaded the signed bid document online. And the reason for non-submission, lordship will find page 63, the bid document.
Yes.
Page 63, clause 19, sealing and marking of bids for offline submission. So here the instructions have been given for offline submission, and lordship, Roman 1, at the foot of Roman 1, note, hard copy of bid document need not be submitted along with supporting documents.
No, but learned single judges relied upon the condition number 8.
My lord.
Read the judgment.
Judgment, my lord.
Yes.
Yes. Judgment, my lord. Page 124, my lord. Operative part, my lord.
No, not operative part.
Lordship wants me to read clause 18. Yes. Clause 18, my lord. Page 62. Submission of bid, online mode, offline mode. Only online bid will be accepted. Both technical and financial bid will have to upload through online mode. However, one hard copy of technical bid, that is a supporting document self-attested of the technical bid, is to be submitted in the office of the Superintending Engineer, Nagaon Circle, Irrigation, Nagaon, for verification and checking authenticity of documents during evaluation. My lord, I have submitted my technical bid. All the supporting documents I have submitted. The only thing which I have not submitted is the bid document. That is, as per the tender document, not required to submit. And
No,
my lord,
because if you turn to page 116 again,
116, my lord. Yes.
you are not the only victim of this.
Yes, my lord.
Another party is also there
Yes,
because of
he
the
have not
same
challenged.
reason.
Yes. I don't know whether he have challenged or not, but to my knowledge, he have not challenged, but I am challenging, my lord, because it is their note which specifically mentions the hard copy of bid document need not be submitted. And the bid document, my lord, is this, my lord, the bid document, my lord.
Hold Mr. F. Khan for the petition. Notice.
I'm appearing for the department, Lordship.
Yes.
Lordship, I'm just pointing out 2 notes, Lordship. At page 62, 61, Lordship.
Yes.
617, Lordship. Format and signing of bid, Lordship.
What do you understand by NB?
Lordship, in any bid document, Lordship, furnishing hard copy of the technical bid as necessary, Lordship.
We'll examine it. It does not require to be thrown out. File your replies. Next.
My lord, there was an interim prayer, my lord.
Interim prayer cannot be granted.
My lord.
Next.
Obliged.
You waive the notice for the department.
Yes, sir.
File proper affidavit. Next.
Obliged.
May I please, Your Lordship, this bill has been filed, my lord, against the interim order passed by the Honorable Single Judge, my lord. Page 49 is the order passed by the single judge. The notification has been challenged, but that was
What is your age?
age is just 46 years now.
If it is just or above 45 or not?
My lord, the thing is that the appointment of the Anganwadi helper.
Every appointment, the age limit is there.
Yes, age limit is there, of course, my lord.
I can't say that I am only
No,
63 and continue here as a judge.
Here it is a promotion, my lord. It is a promotion.
Promotion or no promotion?
It is a promotion, my lord.
No, it's not a promotion. It's your viewpoint.
No, it is a promotion, my lord, because helper to Anganwadi worker, he will be promoted.
You were required to apply separately in pursuant to the advertisement. Don't
No,
try
my
to
lord, because being a helper, 10 years experience is required, my lord.
Mr. Counsel, don't try to twist your fact to such an extent that the court may take serious note of it. Did you apply in pursuant to the advertisement dated 24/8/22 or not?
The thing is that, my lord, here, your lordship will find.
Don't twist the matter and say something which is untrue to the court. Never do it. You are a seasoned lawyer.
My lord, here those who are experienced of 10 years.
That may be the criteria. Don't mix up criteria and promotion. I know the difference between both.
Here the notification has been challenged, whether because the Anganwadi helper
Maybe whether technically, even if you are correct, it was pursuant to the advertisement. There were conditions that promotion also may be considered if you are less than 45.
My lord, here the discrimination part is there, my lord.
You have not even argued that before the learned single judge. Don't open your.
Yeah, I have come to the mother. Here only the thing is there. Let me submit, my lord. The appointment of Anganwadi helper age is from 18 to 44 years. The persons who will appoint after, say, suppose 36 years, they will never be, my lord, appointed because by 10 years experience, they will over 45 years. This is the discriminatory ground, my lord.
That is not even your case before the learned single judge.
No, Lord, that is our claim, my lord.
You have not even argued anything before the learned single judge.
No, yes, it's there, in the writ petition, it is there, my lord.
Writ petition, anything may be there. Your only argument before the learned single judge was that, look here, I am 46, the criteria of 45 is bad.
My lord, that notification and whatever, those things are not considered by the learned honorable single judge.
Then you file a review.
We allowed my them.
Otherwise, anything is argued in appeal.
Oh, there may be allowed.
It is a writ petition.
Yes, madam.
Called Mr. So-and-so for the appeal. It is contended by the counsel appearing to the appellant that certain questions were not, which were contentions which were raised, they have not been considered by the learned single. We do not find any such contention having been argued before the learned single. Still, however, the counsel contended that those contentions were taken in the petition and have not been dealt with by the learned single. With the liberty to file appropriate review application before the learned single judge, the petition is disposed of at this stage. Next, appeal is disposed of at this stage. Next.
Same.
Work charge.
18.
May
I please, your lord. Well, I applied being a mustard worker to regularize my service.
Work charge.
Yeah, work charge. Then, actually, by virtue of the decision even taken by the government of Assam, 2005, that all master workers prior to 1/4/93 shall be regularized. According to this was forwarded.
Any scheme is there?
There is a cabinet decision, madam.
Cabinet decision.
Yes.
Notice. Next,
Thereafter, my lord,
we are issuing notice. Let the other side be here.
problem.
Next. Yes, sir.
My lord, the plant of the petitioner is landlocked and the railway had acquired the land, my lord, along with the passage, my lord, which was running there, my lord. And that has been used by besides petitioner for other corporations also, companies also. Now, my lord, they want to ask the petitioner that we will dismantle the road and you provide a boundary wall and our entire access to the plant will be closed, my lord. My lord, my only grievance is, my lord, that we have nothing to say object about the project of the railway. Only thing is that there could have been a mediation to sit on the negotiation table to have whether an alternate route can be provided.
No, but Mr. Counsel, how are you in possession of this? It is not an easementary right.
No, I have nothing. Ownership is not
It
there.
is not an ownership. It is not easementary also. It is only Balmansai of the, which in Hindi or Gujarati it is known as Balmansai. That the officers permitted this type of use. It's not even a permissive use.
Yes.
Therefore, there should be some right which exists in the appellant. What right you have?
My lord, at least some time
Sitting
may be
on
given to
table and
explore.
mediation and all, if there is any resemblance of right, we can expect the authorities to do it. Otherwise, we don't say for a moment that you are a trespasser, but you have not acquired any right in your favor.
No, we don't acquire any right.
Then where is the question? See the
My lord,
prayers that you have prayed for.
My lord, there will be no access to our land, my lord, and our factory, my lord. Everybody will be thrown out of employment, my lord.
That you can fight out for your easementary right, the right of way, if it is a right of necessity, but you can assail that in a writ petition.
Yeah.
Right of necessity may be there if you are correct. Why should we examine that? There is no fundamental right involved in this. And
If the respondents were asked to sit on the negotiation table, my lord, I am sure that some alternate arrangement can be managed, my lord,
so you please
without disturbing their project.
Please turn to page 95. Page 95, annexure 70. Last paragraph. It is therefore requested. Are we together, sir?
Yes, sir.
It is therefore requested to have your own approach road directly connecting to PWD main road away from railway land as soon as possible.
Yes, sir.
Then next page. Therefore, you are hereby advised to make alternative arrangement of approach road to your premises. Therefore, there is no question of even easement of necessity. It is already there. You have to do it, for which you may have to incur some expenses. What I have gauged through is this litigation is to see that expenses is avoided. It can be done.
My lord, at least
Even if the railway advocates merely sit in the court and watch the proceedings, they don't appear, that is another aspect.
My lord, at least 2 months time may be extended, my lord, so that we can make the alternate arrangement and people are not thrown out of employment at least. The factory is not closed.
Already, Lordship, extension was granted till 39 and the order was of 2020, Lordship.
We are conscious about it. Even otherwise, you are not going to do anything during puja.
I am asking for only an extension of 2 months time, my lord.
No, 2 months is out of question. Heard Mr. S.S. Sharma, then counsel, senior counsel assisted by so and so for the appellant in both the appeals. 2 appeals are there? No, in the appeal. And Ms. Cohen, on advance copy.
One minute.
You are for SDI,
Yes.
for deputy. Solicitor General of India.
For the railways also.
Yes,
Now
Lordship.
they have one panel.
For all Lordship.
All throughout India. Separate panels have been given a go by way of this appeal. The appellant original petitioners have challenged the order dated 21/5/2020 passed by this court in writ petition civil number 12. No, sorry. It's not. Order dated 24/8/2022. The learned single judge having dissected the facts on record and was pleased to dismiss the petition. However, was pleased to extend the time for vacating till 30th of September 2020. The present appeal is filed on 29th of September 2022, just a week before the same. A single judge has observed thus in para 10, 12 and 11 without expressing any opinion on merit. The appeal is not entertained as we do not find any error in the impugned judgment and order. However, the time to at this juncture, Mr. S.S. Karmal and senior advocate contended that the time to vacate may be extended till 2 months. Such request cannot be exceeded. However, considering the ensuing puja days, time as granted by the learned single judge is extended till a time granted by the learned single judge to vacate the pending question is extended till 15th of October. Dismissed on merit. If the appeal is disposed of, connected civil application also would be then dismissed. Next. Yes, Mr. Majmudar was to take some.
May I please? The last occasion, my lord, respondents were directed to produce the record.
Mr. Majmudar was appearing.
Yes, on the last occasion, Mr. Majumdar was there.
Today, Pathak is there.
Today, Pathak is there.
He is in some personal difficulty today. Lordship, I had gone through the petition. It appears an admission has been made by the petitioner himself before the learned thing in the writ petition that a written test was conducted. So now, Your Lordship, perhaps what was, it's my submission, Lordship, what was perhaps not pleaded before the learned single judge was that whether the written test which was conducted, Your Lordship, whether it conformed to Rule 4.3 or not.
No, he was to bring the record also, I think.
Yes, but if on that,
yes, my lord, on the learned single judge has passed the order on the fact that, my lord, written test was not held, my lord. And on the statement of the writ petitioner as well as in my affidavit, my lord, we got on record that, my lord, written test was held. This is not on dispute, my lord. And on that count only, my lord, selection was set aside. That written test was not found.
So if on that limited ground, whether that written test conforms to Rule 4.3 or not, perhaps it can be remanded back subject to what you're.
Let Mr. Where is Mr. Majmudar?
He had to travel out of session today.
Should we keep it on Thursday?
Yes.
Day after tomorrow.
Yes, Lord.
Then
I'll ask him to
put an
be
end to it. Day after tomorrow.
Very much.
May it please your lordship. My lord, as per the last direction, my lord, it appears that the respondent number 6 has filed one affidavit, my lord. I have done through the same, my lord.
May it please your lordship. My lord, Mr. S. Bora will appear in this matter, my lord. He's on legs in another court. I pray that the matter will pass over for the time.
Pass over.
May I please your lordships? Mr. A.R. Bhuya is on legs, so kindly pass over the matter for time being.
Pass over.
Obliged.
Government is supposed to give the acquisition.
Yes, my lord, preliminary notification has been issued, sir.
Underbridge.
Railway underbridge.
Railway underbridge.
My lord,
Railway underbridge.
yes. Not railway underbridge, that's a separate road, construction of road.
And it's a 400 meters only. Your lordship may direct them to complete it within a period of some period.
Mr. Das, that the statute gives them power period. What period?
Yes, period is there.
We'll record that this progress is there. So your prayers get answered. Your main prayer in the petition, if you turn to page 20.
Yes, yes.
But we'll also provide some jumps in our order so that it may not be, no lethargy may be there.
That is what.
Otherwise, we can.
Otherwise, it's a 400 meters road which will connect to the.
Mr. Bora, you place that on record.
Yes.
Heard, Mr. Okay, take this step back. And so for this one, R. Bora, the senior government advocate for the state authorities, and Mr. S. Chakravarti. S. Chakravarti.
He is with me. He is with me.
Five is public interest litigation. The petitioner has prayed for the following relief. Page 26, para 22. Correct. Suffice it to note that in response to the notice issued by this court, the respondent authorities have filed affidavit. Ultimately today, Mr. R.K. Bora, an additional senior government advocate Assam, has produced on record the communication dated 23rd of September 2022, along with the photocopy of the preliminary notification published in English Daily Assam Tribune and Neomia Barpeta on 23rd of September 2022. The same is taken on record in view of the state development which has been brought on record. The prayer prayed for in this petition substantially gets answered. The railway authority, state as well as railway authorities shall complete the acquisition and carry out the project as expeditiously as possible. Sir, you appear for the railway?
Lord, if your lordship gives the time, 6 months or so.
No, Mr. Gupta, probably even under the new Land Acquisition Act, the time is
yes.
2 years. Even otherwise, it is there. We can curtail it. Otherwise, it could have been done by now. There is a under the new act, It can be done by reconciliation also. So if that happens, it can be done within a week, but we don't, that is.
My lord, the petition will be kept pending or?
No.
You're disposing.
Disposing of.
I deeply obliged. If they do not do anything, we should have.
You will have to come again.
That is the lordship. Because otherwise 2
Proceedings
years.
then closed at this stage. Next.
Please, your lord. In both these matters, I have made a small synopsis of the gist of the matter as well as my submission. I am submitting that. It will be easier for your lordship to appreciate the facts and circumstances of this case. At the afternoon. Basically, this matter relates to promotion. Your lordship. I have challenged that on 2-3 grounds. Basically, the first is the clubbing of the different years of post, your lordship, for different years together. That is the first point. Then there is a violation of their own rules and regulations. And your lordship, the reservation part is also not been clearly observed.
You are the only appellant who has come, or others have also come?
Lordship?
You are the only, because 3 petitions were dismissed.
There are 2 petitions, your lordship.
2. The third one has not come.
There's none. The both have come. It is together, your lordship.
Okay.
And I have given it only for the first one because facts are practically same in both the cases. So I have given only in one. I have made the mention with regard to the other ones. Lordship will kindly, I'll refer to the.
We'll have to fix this matter. We'll have to fix this matter for hearing. We'll do it. Next.
Lordship will give the synopsis of the submission.
That we have retained.
Yes.
The respondents may also file if you want.
Gotcha. Next.
That's it.
Service is awaited. Service awaited. Section 2 so and so. Here service is awaited.
Lordship, as per office note, lordship 14 to lordship 14/9 lordship. AD card has been received back, lordship. And lordship, in the meantime, lordship, the respondent has given khula talak to me, lordship. During the pendency of this appeal, lordship.
Is it on record?
This is not on record, lordship. I have.
You brought it on record?
No, lordship.
Then?
Because this is an appeal.
Lordship,
you can't take into consideration any new facts like that.
If you lordship permit, I can.
No, you have to file proper application for that. It would amount to additional evidence.
My lord.
And I don't think that it has any bearing on this. It has no bearing on this. Still, however, you wait. Even if it is served, the other side will have to appear.
Okay. Then lordship, we can wait.
So served, no one appears for the respondent. You are for the husband.
Lordship.
Next.
Deeply obliged.
Our affidavit, I'm preparing for respondent number 3. Our affidavit is ready. Will be filing by tomorrow.
At the request of Mr. P.T. Das. SO to so and so, agent to so and so for filing affidavit. Next. Is your
my lord, step was taken, my lord, as per office to dated, my lord, 23/9/2022, awaiting submission.
You those have review full review the
Steps was taken, my lord, and my lord, pursuant to my office note dated 23/9/2022, my lord, awaiting service report in response number 1 to 7, my lord.
await service. Agent to 4th of November. Next.
March.
He will not come. Keep it all along with that matter. She is there for Kyle.
May I please your lordship, your lordship service report awaited, your lordship. We are appearing for the first time, my lordship.
He is working in income tax department.
Yes, your lordship.
They take dusty service and serve him. He must be there at Shillong.
Your lordship,
Press notice to respondent. Dusty service permitted. Returnable on 22nd of October. Next.
26.
22nd of October. Sorry,
Deeply
22nd
obliged.
is a holiday. Sorry.
Deeply.
Wait. 20th of October.
20.
20.
Yeah, please, Your
Respondent has appeared.
Your lordship, there is a delay of 39 days.
We'll condone the delay.
I objection, lordship. I will file my objection, my lord.
Objection, no objection.
My lord, they have not explained anything, my lord.
Even if it is 390 days, we will condone the delay. Next.
Objection.
39 days, what object? You mentioned 87 Supreme Court in our order. Next. The appeal bill.
My lord,
set
so
for-
far this matter is concerned, it is still for stay, my lord. For grant of the stay, my lord.
Who is for the respondent?
Lordship,
For the state of Nagaland, the central pollution.
There is nothing like stay of stage of stay.
My
Last
lord,
time affidavit in reply was.
yes, has already been filed.
That we
And-
have filed. That was the stage.
Yes, so that, my lord, the stay matter may kindly be heard and disposed of.
There is the. Huh?
Stay matter may kindly be heard.
Matter will be heard finally.
Matter will be heard, but let the.
Who's for the union?
Union assistant name is given, my lord, but he is not urgent.
Because you have challenged the rules of the central
Yes.
government, therefore.
I have challenged.
Kind of single use plug.
Hmm?
I think single use plug.
A single use. Because this is implemented all throughout the country, isn't it?
Yes, that is there.
And there are petitions in other high courts also.
Yes, my lord, so far the Jharkhand High Court is concerned, I have heard about it. But so far the other high courts are concerned, I do not know, man.
It is so. I had read somewhere, 1 or 2 high courts. You are for?
Lordship, I am for respondent number 1 and 2, your lordship. Lordship, we have filed our affidavit, lordship opposition, and they filed the reply also, lordship.
We'll fix the matter for hearing.
Yes, lordship.
My lord, in that case, let it be listed after 15th November, my lord. And
Mr.
at
P.
the,
Sharma. No further pleadings you want to file? Pleadings are over.
Lordship, I have to file only the committee, lordship, the expert committee report, lordship, that I have filed, lordship. And apart from that, I have stated some of the points in maintainability, lordship. That's all, lordship.
You are for Union of India?
Lordship, for the Union of India.
The matter be fixed for.
my lord, at the stage of admission, this matter may kindly be disposed of after 15th November, my lord.
16th
Let it be
November.
listed for admission, my lord.
16th of November. Next 16th.
Monday.
Diary.
Also, there is a delay of 100 days of filing this appeal. Lord.
Who appears for the Power Grid Associate? Anybody there?
Notice has to be issued. It's a private party, Lordship.
Private party. Notice returnable after 4 weeks.
Your Lordship. There is a delay of 137 days, Your Lordship.
You are for the respondent?
Yes, my lord.
Respondent.
Well, in item number 43, it speaks for submission of written submission. Right.
Both sides are
Yes, ma'am.
submitted. The learned advocates appearing for both the sides have submitted the written submission in form of argument. Same are taken on record. No further argument would be necessary now
Yes, madam.
for order.
My lord, item number 43, 44, Lordship. We have
44 अभी आएगा.
44, no, my lord, it is not that somebody mentioned whose name
43.
does not reflect in the cause list.
This is 43.
Sorry, sir.
Please wait.
Yes, ma'am.
You give this date in this 8th of November. अगर जल्दी हो गया तो फोन करते जजमेंट इस yes.
My lord, the item number 44, we are for the respondent. The interview was infectious. And they, without information, without consent, it is learned that they have mentioned the case. And the lawyer who mentioned it, his name does not reflect in the cause list also. It is learned now.
Say, Mr. Counsel, don't find fault with the court. Somebody mentions, we grant them time.
My lord, but they did not obtain any consent, did not inform us. And
When have we kept it? 1611. We'll prepone it.
My lord, the problem is this. Taking the advantage, telling that this case is pending, the repetition which have challenged another order, they will place this, that the retable is pending. And they have locked the door. How big is done?
So what is your request?
My lord.
What is your request?
In this case. My lord, the retable is infectious.
No, but what is your request today? We have adjourned the matter at the request of somebody. What is your request today? Please tell us. Instead of finding fault with all, as if we have committed some mistake.
Let it be taken up, my lord, day after tomorrow.
Then request that day after tomorrow.
My lord, obliged.
You inform the other side.
Yes, my lord, much obliged. Much obliged.
There. And then call out so that it will.
This is regarding the Bahini River, my lord. Most of the, my lord,
only two parties are. It was by near of advocate. He was waiting for this very advocate. The rest are no 44 days. Yes.
Lordship, most of the, my lord, bridges over this Bahini River, my lord, has been demolished. Some illegal bridges are still there, my lord. But, my lord, the petitioner, as the petitioner has already expired, my lord, I have talked with the son of the petitioner. He has said the second, the widening of this river has not been, my lord, done anything, because the direction was to widen the river 8.5 meter. But this still, in some places, it is less than 4 meter.
Who has expired?
The petitioner, my lord.
Then you will have to take steps if you want to.
Yes, my lord. Since Ministry contempt case, my lord, arising out of a PIL, my lord,
I have informed earlier also, but since my lord, it is in between the court and the learned, my lord, the respondents. Therefore, I was allowed to continue.
No, no, that we'll allow to continue, but we'll have to state that
the son or maybe the wife is also very old. The petitioner was also very old.
maybe then we'll
Ah.
take care of it in the order that we
My lord,
can pass.
my lord.
Now, if you turn to the latest affidavit, 9th August 2022, para 1,
Yes, my lord.
are either to be rectified or not, or to be developed. Now,
Yes,
last
yes.
time learned advocate general appeared and we had indicated at page 50 and 51 that many are still to be done.
Done, yes.
But what that will allow us around 6 months time. In the meantime, there are more, the deputy commissioner, the GMC, and the water resource department are involved. They have to work together and demolish, give notice and then demolish, or if required, that height to be increased. So deputy commissioner should supervise the entire exercise. And the entire work can have to be done. But will fix the time within 6 months before the next season of summer season starts.
Yes,
the rectification,
Because
demolition.
last time we had shown it to Mr. Sakia.
Lordship, lordship.
Here. Page 50. It is part of the latest affidavit.
From survey report is from page 9 onward.
9 or 9 is page 50. There are 29 in number.
29.
Then in next page 12 in number, and the third page it is 7 in number. So you will either rectify or demolish all.
Yes, Lord. Not
Within a
only
period.
indicate my lord, deputy commissioner will supervise that
Deputy commissioner of where?
deputy commissioner Kamrup Metro. Along with Commissioner GMC and the water resource department, because the river belongs to the water resource.
Kamrup Metro DC. Then who is the next?
Commissioner GMC, not a municipal corporation.
Municipal Commissioner.
Yes, Commissioner GMC.
GMC. Then
And,
who will be the third?
And the secretary for the water resource department.
Secretary. Water Resources Department.
Yes, please. This is regarding river Bahini, not Bhorolu, but river Bahini. But this GMC water resource department has filed this affidavit stating that they have handed over all the work to the GMC Milord. But yes, GMC Milord will definitely, if you also kindly give a direction to remaining illegal bridges to be demolished, along with my lord, the maintain official river width of this as 8.5 meter all along the course of river Bahini and freeboard 1.5 meter. And as they have for 6 months time, my lord, we have no objection.
These are what you are asking for demolition is what? Access approach roads.
No, illegal.
No, my lord, illegally constructed.
The height is not there.
No, height of what?
Height of the bridge. It should be
1 point.
So who has built these bridges?
Illegal.
Illegal. Some are private persons illegally have been constructed.
So these are meant to for approaches to their individual plots.
Individual house, businesses, and all these things. All along there are bridges. Most of them are demolished. These are the
Now, if you demolish it, who's going to reconstruct it?
those persons who had already constructed, they have to get permission and raise the height or for rectification. Otherwise, it's illegal. It cannot be done. It has to be done.
My lord, during the pendency of the PIL also, some my lord, persons came and filed their IA, but that was disposed of with a direction to demolish all the bridges, all the 99 bridges, illegally constructed bridges. Then, my lord, the GMC has took up this matter, my lord, and by stage wise they have demolished.
You turn to page 45. Forty-six, 45, 46. As per the order of the Honorable High Court Commissioner, the prosecuted committee came to the court. Go to the next page. This four persons committee was there. Then it was surveyed. Listen to me, please. I understand what you want to convey. Then it was found. Go to the page number 49. It was found to be illegal. Therefore, it is not the first sentence. It does not include any of them. It is the committee. What is legal is legal. Both are there. You want to, look at. We'll look into it and then pass the order.
My lord,
Brother wants to have a look at. Day after tomorrow.
Obliged, my lord.
Most probably we'll look into it and keep the order ready.
My lord.
Yes. Day after tomorrow. We'll come at 2. ये तो कॉपी करवा दे.
My lord, this is the matter relating to the Madrasa TET qualified candidates, my lord. They are seeking at par treatment with the other general TET first qualified candidates. My lord.
We'll issue notice.
My lord.
Serve them.
Yes, my lord.
Told Mr. A. Bhuyan for the
A.R. Bhuyan, my lord.
A.R. Bhuyan for the petitioner notice returnable on 14th of November.
My lord.
Dusty service additionally dusty service is permitted.
I will do the needful. Obliged.
In fact, last time we wanted you to serve them a copy and so that you may not have to.
My lord. My lord, perhaps my lord, a copy has been given to our Majumdar, my lord.
But you still serve them. We don't want to wait.
My lord.
Next.
Lord, in this petition, my lord, I seek some accommodation, my lord, after the vacation, my lord. My lord. My lord, the survival is that, my lord, the honorable single judge, my lord, has bifurcated the petitioner into 2 categories, my lord. That on the preferential treatment, some of the petitioner had been given the benefit and we have been, my lord, segregated. Now, my lord, we are claiming that in the merit comparison, we even the better position with the persons, my lord, who has already been given the benefit by the learned single judge, my lord.
You call Mr. Pathak. But ultimately, my brother is correct. Now, what remains in the matter?
My lord, the remains thing, my lord, is that those person who has been given the benefit, the process of appointment is going on. And till date, they have not been appointed, my lord. And secondly, my lord, there are certain numbers of vacancies are available as per the statement made by my learned friend Pathak.
No, that is okay. But if you look to,
because my lord, the learned single judge, my lord, what the order has said that the sum of the persons. So,
are you in this matter or the earlier matter?
in this matter, no, this is for it. My friend is in the earlier matter. I have informed him that.
You received the copy of the petition or a copy?
Yes, ma'am.
Then you write no so and so appears for the respondents. No formal steps are necessary to be taken for service to the respondent. You file whatever you want to. We have kept it on 14th of November.
14th.
Say, Mr. Bhuyan,
My lord.
please turn to your prayers that you have prayed for.
In the writ appeal, my lord.
Yes, not in the writ appeal, in the writ petition.
In the writ petition, my lord. Yes, my lord.
It's probably 71 or 74. 75.
Yes, my lord. 75 is the prayer, my lord. It starts with a
They
read in the
produce
minutes.
and submit records of interview. Now that is out of question. Then P redirecting command is not which is to produce furnish select list.
My lord.
Then restraining, prohibiting 14 posts, 4 from general post. These are your prayers.
My lord.
Now turn to the last paragraph of the impugned judgment, or paragraph 10.
My lord, the paragraph 10 says, my lord, that the setting the insofar as the other petitioners are concerned, my lord, the said writ petitioners are pressing for, lord, setting aside the select list on the ground of section 4 of the Assam Scheduled Caste and Scheduled Tribes Reservation of the Vacancies in Services and Posts Act 1978, as well as the Rule 4 of the Assam Scheduled Caste and Scheduled Tribes Reservation of Vacancies in Services and Posts Rules 1983. In this connection, if the said select list dated 08/02/2011 as published in the newspaper on 12/2/2011 is interfered with, it would have the effect of disturbing the appointments made to a large number of 702 selected candidates who have put in about 8 years of service pursuant to the select list published on 8/2/2011. Therefore, in respect of the petitioners, other than the petitioners number 1, 2, 8, 9, and 14 are concerned, this court is not inclined to interfere with the said select list as the appointed candidates cannot be disturbed. Moreover, it is not a case of the petitioners that the reservation policy has not been followed, and as such, the non-bifurcation of the select list in terms of the 1978 Act and 1983 rules in this case is held to be mere irregularity which does not vitiate the selection process, because in this case in hand, the form of results as published in newspapers cannot be solitary ground to set aside the entire selection process. Under such circumstances and discussion, the petitioners, other than the petitioners number 1, 2, 8, 9, and 14, are not found entitled to any relief.
Now, who are the appellants?
My lord, the appellants are the rest of the petitioners, my lord. The petitioner who has not been given the benefits.
So 3 to 7.
My lord, 3 to 7, my lord.
But they are 3 to 7 and 10 to 13.
My lord, my lord.
So 4 plus 4, 8. 6 are before us. 7
Yes,
are before us.
7 before your.
One is not. Now, therefore,
lord.
on what basis you say that you are you should be
Treated at par, my lord.
No, you are entitled to this benefit.
Because, my lord, the bifurcation which has been made, that the learned single judge has held that the prayer has been differently made. Actually, no, my lord, there is no different prayer of the two sets of petitioner, my
Because
lord.
702 persons were selected in 2011.
Correct, my lord.
Means 11 years ago.
Yes, my lord.
Today, the age of the appellants may be of what age?
No, my lord, the issue was that before the learned single judge, my lord, the prayer which they have made is in the one and identical prayer they have made, my lord. All the writ petitioners.
No, that we have seen.
My lord.
But the question is that today you all may be over age.
My lord, these persons, when this writ petition was allowed, my lord, as per the AB
No,
constable.
it was not allowed by you. Therefore, you are here.
My lord.
It
my
was
lord.
dismissed in 2019.
That is correct, my lord. No, my lord, that's why we are.
And to relate back them to recruitment of 11 years
11 years
ago.
ago. My lord.
Many things may have changed.
My lord, that I have to, my lord, agree by my lord.
Many floods have come in
But my lord,
Brahmaputra in this 11 years.
My lord, may kindly appreciate, my lord. These are the, my lord,
I
people, my
understand
lord.
there may be some heartburning because they have
My
been
lord.
left out.
My lord.
But
And
now-
the manner in which, my lord, we
Now
have been
to
class.
set the clock back after 12 years, Mr. Bhuyan, it would be very, very difficult for any authority.
But my lord, as per the learned single judge's order, my lord, some of the person is going to be appointed of the same batch, my lord, same writ
No, but
petition.
they're because they were found to be entitled on the
That is the
qualification.
My lord, my lord,
Qualification.
my lord. That is
Now you go further. See, if you visualize from page number annexure 1, all you annex those vocational training and all that.
Yes, yes. my lord.
Now this ultimately it relates to the eligibility criteria for the recruitment.
That is correct, my lord.
If
But
these 7 appellants do not fall within the eligibility criteria, they don't satisfy the eligibility criteria. Now, after 12 years to re-examine all this would be impossible.
My lord, May I submit, my lord? My lord, the ground of the learned single judge
And they
was
must
there.
be doing something in their life.
My lord,
They are 32, 33 years old. I have calculated it while reading the
they
paper
are
for
not
the first
sitting
time.
idle otherwise. my lord.
Naturally.
They are not sitting idle. They are youths, my lord. My lord, searching for
In 19, for example, appellant number 1 was 30 years old. Today he or she would be 33.
my lord.
To ask the government to appoint her now, him or her at the age of 32, 33, it would virtually be impossible.
But my lord,
And the learned single, we could understand that learned single judge has not rationally divided
My
the
lord.
petitioners. It
Yes,
is
my
on the eligibility that it has been bifurcated.
But my lord, that eligibility which has been picked up, my lord, is on the basis of the preferential treatment. Now, my lord, with my limited knowledge, my lord, what I respectfully beg to submit, my lord, is that preferential treatment would come, my lord, when somebody is similarly situated. Now, here is a case, my lord, wherein the applicant is scored more marks on merit, my lord, than the person who has been given the benefit, my lord.
No, more marks in what? In the
Interview, my lord.
in the recruitment.
Yes, my lord, in the
But
recruitment,
the
my lord.
question is that if the person with more marks does not possess the requisite qualification, then marks has no value.
No, my lord, requisite qualification we have only basing on the preferential treatment, my lord. This additional added qualification, my lord, the learned single judge has picked that those person have these, and therefore they should get the preferential
Actually,
treatment, my lord.
you read the learned single judges.
My lord, that observation, my lord, may be pleased to find, my lord. At paragraph, my lord, 8.
Yes.
Paragraph 8, may I read, my lord?
Yes, yes.
Under the normal circumstances, generally when there is a tie of marks awarded for the two candidates, the principle of adding weightage for extracurricular activities are required to be considered, and accordingly, a candidate possessing NCC certificate or those who have represented the state in sports, martial arts, etc., or having skills in tradecraft like the computer, motor driving, electrician, etc., are given due weightage. In the present case in hand, on the basis of record produced, it is not possible to find out whether there was a tie of marks between any other selected candidates and the petitioner numbers 1, 2, 8, 9, and 14. My lord, I am pausing for a moment here, my lord. My lord, the learned single judge was also not aware, my lord, that whether this preferential treatment or the, my lord, basis of weightage could be given if there is any tie of marks was there with petitioner number 1, 2, 8, and 9, my lord. In absence of any clarity in the record produced with regard to the effect whether due weightage was given to the concerned petitioner number, this court is unable to arriving at a finding that the parameters as reflected was duly followed for giving due weightage to the petitioner number so and so, my lord.
So, was there any criteria provided for giving additional marks to NCC certificate?
My lord, if my lord may be pleased to peruse the advertise, my lord. The advertise has, my lord, yes, my lord. My lord, may kindly for a moment, my lord, the advertisement.
My lord, I'm very sorry, my lord. This matter was trusted to Mr. KP Pathak, my lord, but due to some reason he had to leave court early, my lord. It is not with me, my lord. My lord, the brief is also in maybe. It is interested to email me.
Day after tomorrow.
Day after. Very
well.
No.
Day after tomorrow, Mr. Goyal. Described as mentioned in para 3 of the judgment that
Yes, ma'am.
NCC certificate also would be required.
Required.
Now it is not now. Therefore, learned single judge has taken out those candidates who had
Who
possessed
has
that.
those qualifications?
Now, admittedly, the appellants, these 7 appellants do not have that.
My lord.
So think it over. Therefore,
ma'am.
we are saying that what remains